Welcome again to all of you. My name is Sandy Horner. I'm the Director of Wealth Management here at BWFA, and on behalf of not only all of us at BWFA, but everybody at Elville and Associates, welcome and thank you for coming to lunch with us. Today, as you know, we have a topic of elder law, and that's what we're going to spend the majority of our time on. I know many of you are visiting us for the first time, so I'm going to take maybe 5 minutes or less just to share a little bit of information about your host firm here, Baltimore Washington Financial Advisors, and then I'm going to turn it over to Steve Elville, who's going to do all the heavy lifting and take you through the complicated stuff, so I get the easy job. So since there are so many of you here for the first time, I'll just share a couple of housekeeping notes with you so you know the lay of the land. If you're looking for the restroom, ladies, you are out our front glass doors and to the left, and you need to stop and grab the key off the counter, which should be readily visible, and if it's not, just anybody sitting there will point you in the direction of the key. And for any gentlemen, you are out the door and to the right, and you do not need a key. And for months and months and months and months, I have dispensed with reminding people that now would be a good time to mute their cell phone. And wouldn't you know, last week, right in the middle of a seminar, somebody got a phone call, which is no big deal. I was a little surprised that they actually took the phone call at the table in the middle of the seminar. So I would respectfully ask all of you, if you haven't muted your phone and you do get a call, you're welcome to take it. Just please step outside of the room. You'll notice also there's some pens on the table, and you have copies of the slides, and there's note paper available. So I think you're in good shape to take notes, but if you need something that you don't have, again, just let us know. Okay? Great. So again, I'm just going to share with you a little bit about who Baltimore Washington Financial Advisors is, and then I'll turn it over to Steve. We are a 32-year-old Howard County based, we've been here the whole time, registered investment advisory firm. We work in a team approach. We work in a very transparent business model. We are, by definition, a fiduciary. We offer investment management, financial planning, taxes. In case any of you are a business owner, we actually offer a business services group too. And we try to do all of these services in a very human way. We try to make it as easy as we can, and we try to help you make smart, confident, and ethical, unbiased decisions about good choices with your finances. So I'm going to talk about a couple of those aspects for just another moment or two, as I said, and then I'm going to turn it over to Steve. How many of you know exactly, and I will tell you, I'm setting you up for a bit of a trick question here, what a fiduciary is? Show of hands. I see one, I see two, okay. I know you know what a fiduciary is, and Meryl, since I spoke with you before the seminar, I know you know what it is. For everybody else, I'm going to share with you what a fiduciary is in the financial services world. The polls out there generally indicate that about 90+% of people say they understand it, but about 7% of people can actually explain what it is. And so it's important from my perspective, the one tidbit I want you to walk away with is knowing the difference between fiduciaries and non-fiduciaries when it comes to financial advisors like BWFA. So as a fiduciary, BWFA is morally and ethically and legally bound to always put your interest or our client's interest ahead of our own. So for example, we don't charge commissions or anything of that nature. We never buy anything for our clients which pays us extra or bonuses or anything like that, okay? We're completely objective, and we work everything. And Greg, can you close that on the way in? Thank you. We work everything on a flat fee. What may be a surprise to you is that's about 10% of the financial advisors in the industry. The other 90%, or the lion's share of financial advisors, are non-fiduciaries. which means they are not obligated in any way, shape, or form to do what's best for you. They are more than okay, and frankly do, look to sell you products which are suitable for you, but pay them as much as possible through the form of a commission or facsimile thereof. So work with a fiduciary is our advice for you. And if I wasn't clear on that, let me know afterwards, and I'll be happy to share a little bit more with you. Okay? So again, the core services, investments, financial planning, and taxes, all of those work very well, but even better with the partnership of a great law firm, and Elville and Associates is certainly a great partner and a great law firm both. Again, I want to be perfectly clear, there is no tie between our two firms other than we think that Elville does great work, and I won't speak for Steve, but I think he thinks BWFA does great work, and we help each other out by helping our clients out. And so we're delighted to have Steve here today and to dispense with my opening commercial, and thank you for listening to me. I will turn the page and pass the baton over to Steve Elville.
Thank you so much. And I absolutely do agree with that BWFA does a wonderful job, if for no other reason than they believe in client education, and that's what we believe in. So thank you, Sandy. So it's really a privilege for me to be back in this conference room and share information with you today. And just how many of you are dealing with what I would call an elder law situation right now? I know some of you are personally, because I just know some of you. Thank you. You were, okay, all right. So just know, as I share this information with you today, I'm very, very sensitive to your situations, even though I don't know them all by heart. I know the kind of thing you're dealing with. So I know this is not easy information to share. I know it's very heavy information, but I'm very privileged to be able to share it with you. And I also want to ask you, how many of you know what elder law is? How would you define it?
In the shortest couple of words, looking out for what's best for the senior citizen.
Okay, that's a great definition. That's one I had not heard recently. That is a great one. Any other definitions that come to mind? Well, I would just, yes ma'am.
Well, it's about planning for someone's passing.
All right, and so that's kind of an element of estate planning and death planning. Another definition would be that elder law is really estate planning for people that are focused, let's say, on disability planning. And some people would argue housing and social security issues and special needs planning and Medicaid planning and all of those kinds of things, including asset protection planning. So elder law is really a broad concept, and I just wanted to throw that out there for those of you who have not heard that. Well, I just came, and I got over here as fast as I could to be on time. I just came from a legislative session in Annapolis, and I can tell you that the legislators are a bit sleepy when it comes to the elder law issue. So if there's something that you really feel passionate about and you want to advocate for elder law issues, they really do need your encouragement down there. So I just want to throw that out. And a couple of things I'll share with you today along the way that we talked about this morning. Okay, so let's get into this educational session that I'm very privileged to be able to talk to you about in academic terms and sometimes practical terms about these elder law concepts. Some of them you're dealing with personally. And we want to leave plenty of time at the end for questions, so I'm going to get right into the material. So trends in Maryland planning, and I had given this workshop before, and the trend I believe is still the same. Maryland is a very liberal state, if you want to look at it that way, for Medicaid purposes, meaning it's elder law friendly. Now, elder law is not all about Medicaid, but it certainly does have a lot to do with it. So the Republican majority, as you are probably aware, tried to change the Medicaid laws in 2017, or the health care laws, I should say. Tried to change those laws twice in the last year. And of course, that did not work in a direct way. There are some indirect changes that are going on. But largely, the Medicaid financing system, which Maryland is very liberal about, meaning the system that we use as a baseline in elder law, upon which to measure other strategies that may or may not be viable for your situation. Those are all based around the current Medicaid financing law, which have not changed. Now, if they had changed, it would have affected Maryland in a big way. How many of you have heard of the waiver programs? There's something called a waiver program, and it's not something that we can count on. And let me try to explain Medicaid as a baseline concept for this discussion we're getting ready to get into. So you've probably heard of community-based Medicaid, just in the sense of if you are a person or someone you know is a person in need in the community. Community-based Medicaid are those public benefits through the Department of Social Services that are unlimited. So community-based Medicaid is unlimited. Over here on this side, if you can conceptualize this, is long-term care Medicaid. So remember, if I'm in the community and I need services and I don't have assets or income to qualify for them otherwise, I can be eligible for community-based medical assistance. Over here, I could be eligible for long-term care medical assistance. If I needed a nursing home, if I needed skilled nursing, I could qualify for that on an unlimited basis. So unlimited community-based Medicaid, unlimited long-term care Medicaid. But here in the middle, we have something called the waiver programs. And there are several waiver programs. The traumatic brain injury waiver program, the older adults waiver program, which is the one that's most applicable to most of our situations when we talk about elder law. The adult daycare waiver, and many other types of waivers are available, but they are limited by the states. So what does that mean, waiver? It means the federal government has waived the requirement that the states have to provide these benefits on an unlimited basis. So they're waived that. So the waiver slots are limited. So for example, if someone was in Maryland and they needed to be cared for and they had no choice but to go to a nursing home, but let's say they could possibly be rehabilitated and they could live in assisted living, or they could live at home. Most people would like to live at home. Well, the waiver program, if we could qualify for it, allows for someone to receive 10, 12 hours a day of Medicaid services in the home. But there's only about 5,000 slots for this because the states can limit it. So there's about 23 to 25,000 people on the waiting list for this. And we won't spend time getting into this today, but that's if we were trying to qualify for the waiver programs directly. But indirectly, if one has to go to a nursing home, there is an indirect way to get the waiver programs, if it's appropriate. So if we can get it the indirect way, which unfortunately involves a nursing home stay for a long period of time, which obviously is not very nice, but that is an indirect way of getting that waiver program. So think in terms of the Medicaid baseline concepts that I'm going to talk to you about today as community-based Medicaid, long-term care Medicaid, and the waiver programs as kind of a wild card that if we are lucky, we might be eligible for a waiver slot. So Maryland's trends are that it's very liberal except for this limitation on the waiver slots. So if someone were living in another state, just to show you how liberal Maryland is, if someone were to reside in Maryland for one day in a nursing home, they would be considered to be a Maryland resident for Medicaid purposes. So Maryland's very, very liberal in allowing people to qualify for Medicaid. But those waiver slots are a problem. And so we've kind of talked about the federal law and the Affordable Care Act that was not repealed, okay? But we have these major problems. The waiver slots are limited, okay? And the waiver programs in general are going to be affected. Hundreds of millions of dollars would be affected, which they haven't been yet, would be affected if there's a change in the way health care is delivered. The augmented estate legislation. So right now, this is just a quick update. We're in the middle of the legislative process. So there is a technique in the elder law context. Now, remember we talked about what is elder law. It's estate planning where someone has a disability. It's estate planning, so let's pretend you're a couple, a married couple, and we want to do some kind of asset preservation between the spouses. So asset preservation, which we're going to talk to, is very complicated, but this is something that federal law allows. So let's pretend I had an impaired spouse. One of the maxims of elder law, and it's not applicable to everyone, your level of assets might dictate that this is not a good idea. but the average person would get assets out of the disabled person's name. So let's pretend we moved assets out of the disabled spouse's name into the name of the well spouse. But now, what does the well spouse do? Well, under federal law, the well spouse can leave the assets to the disabled spouse if the well spouse were to die first, and there's a technique for being able to preserve all of those assets in a trust if the well spouse were to die first. Now, is it likely that the well spouse would die first? Probably not, but sometimes it does happen. So this is an asset preservation technique. Well, to make a long story short, the augmented estate is something that the legislature is looking at right now, and it will affect our ability to be able to preserve assets under that strategy, which a lot of spouses use. They use that strategy. It is a will-based strategy, not a revocable trust strategy. So just know that the augmented estate legislation, which you can read about in the legislature, is it's an initiative to try to make it more difficult to preserve assets from Maryland being able to make a claim against the assets and being able to preserve assets fully for the well spouse, for the disabled spouse, should the well spouse die first. So that's a complicated explanation. Yes, sir?
How does the 5-year look back apply?
All right, so that is a great question, and this is one of the misconceptions that a lot of people have, and I'm glad you asked that. The question is, how does the 5-year look period apply? So many of you may remember that years ago, this was the 3-year look period, and this was before 2006. And then under the Bush administration, this was changed to 5 years. And what it basically means is this. First of all, there is no penalty for transfers between spouses. So let's pretend spouses are transferring assets back and forth. The 5-year look period has nothing to do with that. But let's pretend that a spouse transfers assets to a third party, like a child, a friend, a niece or nephew. That starts the imaginary 5-year period, and the best way to look at it is a 5-year look forward period. So you look forward into the future. This is always called a look back period, but I think you should call it a look forward period. If assets are transferred and 5 years goes by and there's no application for Medicaid within 5 years, then those assets under the current law escape a Medicaid spend down. So there's a technique, there's several techniques that can be used. Of course, outright gifts and so forth. So we're going to talk about that. But that's what the 5-year look period is all about. It's a period that if you apply for Medicaid before the end of 5 years, there will be a penalty. A penalty. Now, under Janet Reno in the Clinton years, this is not, she tried to make it a criminal penalty, but it's not a criminal penalty, it's a civil penalty. So let's pretend I transferred $80,000 basically to my child, and then I applied for Medicaid the next month. Medicaid would say, no, Steve, you can't do that. You just gave away $80,000. They would take my $80,000 and they would divide that by the divisor. Now, I'm not expecting you to remember all this. And the divisor is currently $8,684. So for every $8,684 I give away, I will be ineligible for Medicaid for 1 month. So think in terms of about $8,500, I'm penalized for 1 month. So $80,000 divided by $8,500, that's the number of months I would be ineligible. Does that make any sense? It's a penalty, but it's a civil monetary penalty. Cost of care continues to go up, so that's no surprise. And I was talking to someone here just a moment ago that was talking about the incredible cost of care. So just know that that's not changed. It continues to go up. Thus, looking at your portfolio, we attorneys, we're not financial advisors, but looking at the portfolio, how can we generate income under these circumstances? How can we work with our CPA and tax advisors? You know, what can we do to generate all sources of income to try to pay for the cost of care? Long-term care products in advance, of course. Hybrid products of all kinds. Sandy can talk to you about that kind of thing. And of course, elder abuse continues to be on the rise. No surprise of this, right? And I personally have seen clients right here in the Columbia area, in Montgomery County area, Howard County area, lose up to $1 million to scams. and lottery scams and other things, and I know you've seen this. So it's a very serious thing. And I just came from the legislative session down there, and there are bills that are being introduced about civil penalties for elder abuse. So the Elder Law Section Council and the Estates and Trust Section Council of the Bar are trying to work together to get some moral laws in place, because for some reason it's a very difficult thing to try to nail down, surprisingly. All right, so why are clients coming? Yes, ma'am.
Is there anything that would be applied to people that are outside the family? Because I'm dealing with a family situation, not family. A friend has become the guardian over somebody,
Okay.
and before she became guardian for 2 or 3 years, we know the names of the people, but we haven't, done anything with
The
it yet.
names of the people who have
Who were
committed
doing the
financial
financial
abuse?
abuse,
Okay.
yes.
Okay.
Is there anything special
Well,
for
what I
going
would
after
do,
them?
it's very difficult, and I'm sorry to be so discouraging about this, but the best thing to do is to report it to the Attorney General's office, okay? And they can investigate elder abuse. The problem is, and we won't spend a lot of time on this, is trying to connect the dots from the authorities down to the local police, and much of it is very difficult to investigate. I will tell you that, can't remember the name of the officer, but Howard County has a specific officer. I apologize, I can't remember his name, I've met him several times. And he is specifically tasked with elder abuse. And I'm sure you've heard of these scams. There are people who walk right in the house while other people are walking behind the house. There are tree cutting scams. There's all kinds of scams. And anyway, if you call Howard County Police, if it's in Howard County, this particular officer will be tasked with that case. All right, so why are people coming to see elder law attorneys in 2018? Well, obviously age-related issues, obviously. That's what elder law is. It's estate planning for people who have disabilities, okay? Now, generally, there are 2 types of cases, and I'm being very general. There are pre-crisis cases. So let's pretend that a couple or an individual comes to our office and says, I really have a strong desire to preserve my assets. I'm worried about the Medicaid spend down. I'm worried about the loss of my assets. Regardless of where you are on the political spectrum, this is something that people are concerned about. Now, it seems like it's not so much the case in our office, but I know in some practices, in some elder law practices in various states, this is a real emphasis, pre-crisis planning. Now, what we do is we try to talk to clients through the issues, whether it's regular, conventional estate planning or more elder-focused planning, which is asset protection. But what you find in some elder law practices is they're focused on this asset protection, and it's right for many people, and it's not right for other people. Because what it involves the idea of giving up control of your assets. So not everybody is keen to do that, and other people are. So it's really a matter of what are the client's goals. But a pre-crisis planning kind of idea is why a lot of people will come to see us. A change of circumstances has occurred, obviously. Memory issues, housing issues, cost issues. Someone wants to apply for veterans benefits. All kinds of change of circumstances could be occurring. And of course, crisis situations. So as you're going to see today, a lot of elder law has to do with asset preservation, but certainly not all of it. So a good way of thinking about elder law, and we're going to get into this, is if you do pre-crisis planning. This is kind of partial elder law planning and setting the groundwork and getting a perspective about the future, what resources are available, but also that has an estate planning element to it. So if we do pre-crisis planning and asset preservation in advance, it is possible to preserve nearly 100% of your assets. And an easy way to think about crisis planning, even though there's nothing fun about crisis planning or crisis itself, if someone has done no advanced planning, but at least if they've done no advanced transfers of assets, but they've at least laid the groundwork for financial management, legal management of their assets, it's possible to save about 50% of the assets under the current law. So even if someone does no pre-crisis planning, it's possible to preserve roughly 50% of the remaining assets. Now, IRAs and 401ks and 403bs, these qualified plans, those are available resources in Maryland. So let's pretend we have a case like this right now. The only asset the family really has is a qualified plan. So yes, we can preserve assets, we can make these transfers as long as a groundwork has been laid legally to be able to do that. But what are we facing if we cash out that retirement asset? Taxes. So the idea would be, in a crisis situation, you can preserve about 50% of the remaining assets, not accounting for taxes. Taxes can be huge, right? So sometimes we do a good job saving for retirement, but now that's going to come back to haunt us if we're trying to do good work on asset preservation and elder law. So there are a lot of contradictions and a lot of financial pain involved in trying to do these transfers, which all dictates do the most you can in advance for long-term care planning, hybrid products, insurance products, all those things that Sandy can talk to you about. All right, what are we talking to clients about in 2018? Healthcare decision making. Okay, we had our client event recently for my firm, and we had the head nurse from Anne Arundel Medical Center come. I only have a connection with them because I'm on a certain fundraising committee on that for that hospital. But they are the third busiest hospital in the state. And so the head nurse there came and talked to us, and she said, the advanced medical directive is only of limited use for them. Only of limited use. Can you imagine that? So, first of all, we want you to have an advanced medical directive. And for those of you who are dealing with loved ones who are impaired or dealing with issues, hopefully they've signed one. Because the most important thing is that it names your agents, it names their agents and your agents. And when we've named an agent, what are we avoiding? We're avoiding adult guardianship. So that's a huge issue. But what they're saying is, from a healthcare perspective, the advanced directive is so general. And now the healthcare decision making at end of life is moved forward to what? The mulched form and other technical types of forms that are being used in end of life situations. And for those of you who have not heard of mulch, we're going to talk about that a little bit. So healthcare decision making, huge. Some people think the advanced medical directive is the most important of all documents. Now I'm going to stop for just a second as we get into financial decision making. Are most people focused on estate tax these days? No. It just came from the Orlando conference, their Heckerling conference, which a lot of estate planners go to. The new exemption amount for estate tax federally is $11.18 million. So as a single person, you can exempt $11.18 million, and as a married couple, almost $22.5 million of assets. So estate tax is not a big issue for most people, although we still have people who are subject to estate tax. So just wanted to throw that out there. So that's dictating that more people, or 99.5% of people, are not focused on estate tax because it's relatively easy to avoid estate tax. And so now the focus is on other things, including elder law, including asset protection. Financial decision making. I was talking to someone right before coming in here. We were talking about whether the person could sign a financial power of attorney. So bare minimum, have a Maryland statutory financial power of attorney, bare minimum. In elder law, is that enough? And we don't have a lot of time to talk about this, but the answer is no. Because remember, the statutory power of attorney, which is the simple form put out by the state of Maryland, which is a good thing, is only meant for basic things. When we're dealing with a crisis or pre-crisis in elder law, are we needing more powers or less powers? We need more. So flexibility is the key with financial decision making. Make sure that you've designed a set of powers of attorney, meaning two, not just one simple financial power of attorney. It's not going to be sufficient to do what is necessary if we're going to engage in planning. In-home management, in-home care management, I should have said. So most people want to live at home. So huge industry, we talked about it in this conference room, geriatric care managers. Those people are out there. And I was telling Sandy once, when I was a young lawyer, they hardly existed at all. There was only 2 or 3 of them in the whole state. Now we have our choice of a lot of really wonderful geriatric care managers, and I would recommend that you only use nurses. There are geriatric care managers who are not RNs, and I would just say you're better off, I think, using an RN. You're getting twice the value for the same money. Nursing home and assisted living placement. I met with a man yesterday who wanted to talk to me about moving into a continuing care retirement community. Read those contracts. I know some of you live in one of those communities now and are very happy. The elder law bar as a whole is skeptical of these places, only because there have been reports of some of these types of institutions failing financially, and you just want to make sure that you've done your due diligence before you move into some of these wonderful places. Some of our happiest clients live in continuing care retirement communities. So don't believe what you hear about the negative side, but do your financial diligence, your due diligence, before you move in. Of course, estate planning does involve, we're going to talk about this, what happens at death, what happens during life. Basic premise of elder law. We're going to talk about the elder law consultation and what needs to happen if you have elder law concerns. Number one thing you can do in advance is to have you and your loved one sign full set of documents, whether it's wills and trusts, and of course a lot of trusts are not friendly to the elder law planning, and that's something that is discussed in an elder law consultation, but the powers of attorney and advance directives. Asset protection, we're going to touch on that a little bit more. Understanding and limiting liability. What if you have caregivers coming into your home? Are you paying them properly? Are you withholding? Is this something that's holding taxes? Is this something that's going to come back and haunt you in the future? Do you have proper insurance? Okay. So what if your employee were to get hurt? Are you hiring people through an agency, or have you hired someone you know that someone knew and who is just a friend? You just have to do your due diligence to be wise in these matters. So contracts, we talked about that. Anytime you're entering a facility, have an attorney read the contract. Medicaid issues, which we've talked about a little bit. Medicare issues. One of the things that most people don't know, and this is one of the big issues that comes up, your loved one went to a hospital. Your loved one was then transferred to a rehab center or a nursing home. How many days are they entitled to under Medicare for long-term care if they spent 3 nights in the hospital?
100 days.
100 days. And what do most facilities try to do? They
Minus 3 weeks.
Minus 3 weeks. The average person only gets 3 or 4 weeks of these Medicare long-term care days. That's because there's an improvement standard, and you've heard of this. If the person's not improving, there's a committee meeting, and then they're given a notice that they're taken off of Medicare. Well, there's a federal case called the JIMO case, J-I-M-M-O, and it came out 3 or 4 years ago, but nursing homes are still doing this. They are still taking people off of Medicare, and saying they're not improving. Well, under the JIMO case, it's not an improvement standard. It is a therapy standard. As long as that person could have been helped by continuing to receive therapy, it's not an improvement standard. So there's an attorney in the Maryland Elder Law Bar who's been very successful with Medicare appeals, which is a very, very difficult thing to do. But by using this improvement standard in the JIMO case, if you have a loved one who's been yanked off of Medicare days, the Medicare days should continue on appeal up to the 100 days. And of course, special needs planning. Now, most special needs planning is done from a third party. Let's pretend that you know or you have a special needs loved one. You would do special needs planning for them by using a special needs trust. But what we're talking about here is also special needs planning between spouses. So there's a way that has to be done using wills. It's not possible to just establish a special needs trust for your spouse, not in Maryland. You can't just take all your assets, put it in a special needs trust for your spouse. You can put all your assets in a special needs trust for someone other than your spouse, but not your spouse. But through the use of wills at death, you can establish a special needs trust for your spouse. And that's an asset protection technique. All right, now I'm going to keep moving a little faster now. What is an elder law consultation? Many of the things we've talked about are discussed, and the best way I can describe it to you is an elder law consultation. Someone has a concern, a crisis has happened, or someone just wants pre-crisis advice. Or we are sitting in a meeting with clients and we're talking about regular estate planning, conventional estate planning, and what sometimes happens. One of the spouses raises the question, what happens if one of us becomes disabled? What happens if one of us has a cognitive impairment? Then what we do, even in conventional estate planning, is we shift gears and we get into this kind of discussion. So this is something that's pervasive, not just in elder law, but in conventional estate planning, because people that are married generally, but it's not always married people, want to know what is going to happen if the worst case happens. And that's what we do in an elder law consultation. Generally, it takes an hour and a half to 2 hours. There's a lot of fact-finding, identifying of problems, going over incapacity issues. We go over many of the things we just discussed, how to finance long-term care. What's one of the biggest things that comes from an elder law consultation? We've got to get those powers of attorney signed quick. If it's possible, we want to really be aggressive and get those powers of attorney signed. Because without those, what are we dealing with? We're dealing with a court. And when we go to court, will the court allow us to do what we need to do? Generally, yes, between spouses. But some of the more advanced strategies about gifting and preservation of assets, the court will not allow. So one of the things about having those documents and making them flexible is you don't need to depend on the court. It serves as a basis for planning. It resolves ambiguities and misconceptions. Now, many of you are dealing with enough for me to say this, but this will be no surprise to you. I'd say about a year ago, I got a referral from someone in Delaware who referred a Maryland client to me. I met them on the Eastern Shore. I drove over there. I met them at a restaurant. And I don't normally meet clients at restaurants, but I met them at a restaurant, and I told Sandy this story. It took me 30 minutes to get this lady to stop crying because she had been told so many misconceptions that she just didn't know what to believe. You know, her husband had dementia. She thought she was going to lose her home, everything she owned. And this really is horrible. Yeah, that kind of misinformation is out there. And finally, I got her to believe that wasn't going to happen. And but it resolves a lot of ambiguities, and that's one of the things that I would encourage you to do. If you know someone who needs one of these consultations, the sooner they get it, the sooner they will feel empowered. So it gives them a sense of direction. It can create family unity. Not all families are created equally. If you or someone you know has a family that's cohesive and they trust one another and they're working toward the benefit of the person who is disabled, that person is tremendously blessed, because that's not always the case. And where there's not unity in the family, these kinds of meetings can try to figure out how can we get a bare minimum amount of unity so that we don't have guardianship, we don't have a meltdown among the family members, and everybody can work for the benefit of the disabled person. All right, I'm just going to check my time quickly. I know it takes a lot of time to get through that. So I'm going to move through this fairly quickly. It's 12:35. We'll want to leave time for questions. Remember that asset protection is a big issue in elder law. And it's a big issue everywhere now, because a lot of estate planning clients are not focused on estate tax. And a lot of attorneys are not focused on estate tax now, because that's the only thing that some of them focused on for years. So now our focus is on other things. Now, lifetime asset protection is something that you should be very familiar with. So I want to distinguish long-term care asset protection and asset protection at death from lifetime asset protection. So let's look at lifetime asset protection real quick. And I think many of you, if you don't know this, you're going to recognize this. For those of you who are married, your husband and wife ownership of assets is going to give you a bare minimum asset protection. It's not 100%, because if both of you get sued, you could lose the asset that is husband and wife. But Maryland is a huge tenants by the entirety state, and other than retirement assets, you should be able to own most of your assets as tenants by the entireties if you are married. Life insurance is protected from the claims of creditors, as long as your spouse or child is the beneficiary. Annuities are protected from the claims of creditors for the same reason. Qualified plans and IRAs are protected, okay? Your IRAs are protected up to $1 million. Your qualified plans are protected in an unlimited way from the claims of creditors. No one can get those assets from you, and you cannot be forced into bankruptcy in those assets. However, if you die and leave your IRA to a child, to someone that's a third party, that inherited IRA is not protected from the claims of creditors, and that's a fairly new thing over the last 6 or 7 years coming down from the Supreme Court. And of course, there is something called an asset protection trust in another state, and there's about 14 or 15 of those states, and Delaware, our neighbor, is one of those states. But that's lifetime asset protection. That's just something that everyone needs to know about. Now, in the long-term care context, okay, that's why we're here today. Pre-crisis planning, we talked about. Someone who's strongly motivated. They say, what can I do to save my house from a Medicaid lien? What can I do to make sure my kids don't have to spend down all of my assets? That's a pre-crisis plan. And it may or may not involve transferring assets. So when we talk about using trusts, and I won't switch screens and draw for you on the whiteboard, but just imagine this. You can transfer assets outright to your loved ones. Is that a good idea? Generally not. And here's why. Once you transfer assets to your loved ones, have you lost control of them? Okay. Can your loved ones lose them inadvertently? Bankruptcy, divorce, car accident, all kinds of contractual disputes, anything could happen. Divorce, okay? So the other thing we might do if we're not careful is we might lose our cost basis adjustment at death, meaning the step up in basis you've probably heard about, which is not applicable to IRAs, but it's applicable to everything else. So use of trust can avoid all of those problems. So let's pretend I have 3 children. I transfer my assets into a Medicaid or Veterans Trust. Now these are just hybrid trusts that are used in elder law. There's no mystery to them, and you could understand that if you read about them. But I transfer them, and one of those 3 kids has a problem. We have a case right now where someone in Annapolis used a lawyer who did a Medicaid trust for 2 sons. The 2 sons are the beneficiaries of the trust. The parents can't be beneficiaries of the trust, or the trust wouldn't work because it has to show that the assets were transferred. But one of the sons is going through a bad divorce right now. And guess what her lawyer said the other day? And during a deposition, her lawyer said, we saw on the land records that your son is the trustee of that trust. And now they want to see a copy of the trust. So through the proper use of trust, a spendthrift clause in that trust will protect the parents from the claims of their child's creditors. So in other words, when you transfer assets to one of these trusts, even if your child has a creditor, that trust is going to protect to the most possible degree the assets that were transferred, and that's a big issue. And we talked about the use of trust under wills, and that is something that's allowed by federal law. That is a elder law strategy. We talked about crisis planning. We talked about saving 50% of the assets. Elder law attorneys for years have called that the half-loaf strategy. The half-loaf strategy. And then there's life estate deeds. So let's pretend that someone comes and they say, Steve, we don't have a lot of assets, but this house, this is a family heirloom. We never want to lose this house. And we just want to do something simple to try to make sure that this house is not subject to Medicaid lien. What can happen is the house can be transferred to the form of ownership called a life estate. And then at that person's death, it automatically goes to children or nieces and nephews, and it does not go through probate. But what makes it a Medicaid technique is that when the house is transferred, the grantor, the owner, gives up the power to sell it. So remember I said to save assets for Medicaid purposes, you have to show that you gave the assets away. You have to part with control of the asset. So with a life estate deed, when the person gives up the power to sell it, they have actually transferred it to their child. So that is a proper strategy for some people, and for other people, the trust strategy is much better. Okay? Now, what if you have assets that are sufficient to manage the cost of care? You have long-term care insurance. You have other hybrid products that could help in the event of long-term care planning. Well, an argument could be made, I don't need to transfer assets because I have sufficient assets to finance Medicaid planning, or long-term care planning. Another argument that could be made is because you do have long-term care insurance, and because you do have assets, and because you have done good planning in the past, that will ensure that whatever you transfer to the trust, and that strategy, it will ensure that everything works. Because remember, after you transfer assets to one of these trusts, how long does it take to get past the 5-year period? 5 years. So who pays for the cost of care during the 5 years if there's a crisis? So if you transfer assets to one of these trusts, we have to figure out what happens during the next 5 years. So you don't want to transfer all assets to the trust. You'd want to hold something in reserve. And if you have long-term care insurance, that can be a tool to make sure that you will, in fact, get past the 5-year period. All right, now at death, I'm going to just make this very quick. Of all the strategies we could talk about today, other than this horrible subject of dying, asset protection at death is easy. Asset protection at death is easy through the use of what is called spendthrift protection. That means that if I give my child a trust, my child's creditors cannot get that trust, just like that Medicaid trust I was telling you about, because it's spendthrift protected. So whether it's a spouse we want to protect under a trust, or whether it's a will that leaves a trust for a spouse, those assets are protected. Whether it's a special needs child, when we use trusts at death, those are protected by use of a spendthrift clause and other techniques. So asset protection of death is very straightforward and very easy, actually. Okay, what do clients want to know when they come in to talk to an elder law attorney these days? Not surprisingly, how do I pay for the cost of assisted living or long-term care skilled nursing? What is the dilemma that most families are in? And we see this every week. Sandy sees it, you see it. My loved one is living in an assisted living, but it's costing a lot, and we can't afford it. And if my loved one was living in a nursing home, the state would pay for it. The federal government would pay for it. That's a terrible thing, isn't it? To have to choose between assisted living and a nursing home. Now, some people need skilled care, and there's no question. They have to be in a nursing home. But there are some people that are right there at what we call level 3 in assisted living, and these people could go either way. And some families are forced to be aggressive and try to get the loved one qualified for skilled nursing. How do I pay for assisted living, assuming that I don't transfer my loved one to skilled nursing? Will I lose my home? The answer is absolutely not. How will I survive in the community? It's not pretty, but the federal government has provided a way for people to survive in the community. And that's called a Medicaid spousal spend down. If you know someone who's worried sick that they're going to lose their home, assure them that they are absolutely not going to lose it, and they will be able to survive in the community. How do we preserve assets? What do I do in general? I'm stuck. I need help to get out of my own way. I'm so upset. I'm so frozen. I can't move forward. There is help available. There are geriatric care nurses that can help with placement, help you put one foot in front of the other and move forward. A team of advisors should include the geriatric care nurse manager in this situation. Your financial advisor, your attorney, your CPA, and a geriatric care nurse. How do I deal with placement? Healthcare decision making. Will I need guardianship? Hopefully guardianship can be avoided, but if we need it, it will be available. Can I get veterans benefits? For a single veteran, for a married veteran, about $2,100 a month tax-free. The Veterans Administration has talked about making this more difficult to qualify for, but so far it's been all talk, and they've never done anything to stop people from qualifying easily. If you transfer assets now to get the veterans benefit, what do we have to have? We have to have a person who is a veteran who was honorably discharged, or at least not dishonorably discharged, and they served in a period of war. They do not have to serve in the theater of war. They just have to serve in one of the major periods. Now they can get this tax-free income. If there's a surviving spouse of a veteran that has not remarried, that has not divorced, that's the key, they can get about $13,000 a year tax-free. We live in a continuing care retirement community. Can I still preserve my assets? There are actually ways of doing that, although it's not the norm. When you enter a continuing care retirement community, you are generally pledging your assets, so to speak, in exchange for some kind of quasi-guarantee that you will be cared for. All right. I'm going to try to keep going here quickly. So, what is the net result of this? Well, first of all, what we don't want to do is what used to happen a lot in Maryland, elder law. We had an old guard of elder law attorneys in Maryland that were known for kind of expounding a lot of information to clients, but not really giving them a lot of direction. So what we want to do in elder law, in my opinion, is provide clients with the information they need to make choices, and then to help them be aggressive in making those choices, because many people are not as fortunate as others, and many people are in a no-win situation. So we want to give them a way forward. Okay? Hard decisions about healthcare decision making. What is happening today with this? A lot, I just heard talk about it this morning, a lot of psychiatric issues on top of the health issues are complicating this area of the law. Placement. People that are very difficult to place. People that have lots of issues and don't necessarily want to move. How we get them placed. Geriatric care nurses can be very helpful. Transfers of assets and level of care. Many people are concerned about, what do I do? Well, the first thing I think you should do is find out what is the level of care of your loved one. What level of care do they need? Should they be living at home? Should they be living in assisted living? Should they be in a skilled nursing home? A lot of people have not really gotten that information yet. There's something called an AERS assessment. A-E-R-S. And this is something you can get through the county. And this is a level of care assessment, the AERS assessment. In my opinion, you should use a private geriatric care nurse, but you don't have to. You could get an AERS assessment. All right.
What
We're
part
not.
of the county?
I would call the Office on Aging. The Office on Aging for each county. Every county has an Office on Aging. All right, we're going to move forward here quickly. I'm not going to spend a lot of time on this, but there are some general strategies that apply to a lot of people. Every situation is different, but basically you're going to see on these couple of slides that after you kind of gather information and you get your mind around what strategies are available to you in elder law, one of the strategies is really to do nothing. Just get as much as you can in place. Powers of attorney, advance directives. Know the information, be empowered by the information, but don't necessarily do anything like do a will and transfer all the assets to the well spouse and these asset transfer techniques, or transfer assets to children. Whereas some other people will want to be more proactive. So it's all goal driven. What is your need? What is your desire? What is your goal? Okay. So I'm not going to spend a lot of time on that, but just know that sometimes doing nothing is the right strategy. I met with someone on Saturday, and I hated to ask this question, but I asked, how long do you think your loved one is going to live? Because do we want to cash out a 401k and incur 40% tax if someone's going to die 2 months later? You know, we don't want to do those things, so sometimes we have to ask hard questions. So part of the elder law strategy is really gathering really rock solid information to the best of our ability. Understanding the nuances of incapacity planning real quickly. Powers of attorney, advance directives, you've heard me pound on that throughout this session. Okay? If you have those proper documents in place, you have put in the maximum amount of flexibility for your situation that you could possibly do. Now, is flexibility the right thing for everyone? There are family situations where providing tremendous flexibility would not be a good idea. So we always have to deal with the particulars of the situation, but generally speaking, you want to have as much flexibility. Now, Understand the MOLST law. Some of you are dealing with this now. How many of you have seen your loved one's MOLST form? All right, 2 people have seen it. MOLST is required under certain circumstances. Real quick, if I'm in a nursing home, if I'm in a rehab center, if I'm in an assisted living, I have to have a medical order for life-sustaining treatment signed by my doctor within 48 hours. I've met with 3 or 4 families over the last month. Many of them have loved ones in a nursing home or assisted living, and I know those people, meaning those loved ones, have MOLST forms that have been completed, but the family members have never seen it, never heard of it, and don't know how it was filled out. So my point is, MOLST is something for you to read about. Go to the Attorney General's website, or email Jeff or Sandy or I, and we will get you the MOLST information. I think what you'll find is there's a lot of misunderstanding about MOLST, and here's why you should read about it in a nutshell. Maryland not only requires MOLST, but Maryland is the only state in the country that requires it. So you should know about MOLST, and if you are an advocate for a loved one, you should know about MOLST, and you should know what it looks like, and you should know what the doctor or nurse practitioner has put into the MOLST form.
Hold on 1 second.
Yeah.
So should one use the MOLST form or the advanced medical?
They are not exclusive of each other. You should have an advanced medical directive if for no other reason than it names your agents. And when you have your healthcare agent, you do not need a guardian of the person. But the ambiguity then begins with where does the advanced directive's general instructions, where does that intersect with the very specific technical instructions of the MOLST form? And that's what I would encourage you to read about. One last thing on MOLST, because we have to wrap up shortly. In the middle between the advanced directive, and I should have brought you a copy today, and I apologize I didn't. In the middle between the advanced directive and the MOLST is something called the worksheet, the MOLST worksheet. I came back from a California elder law conference where the Oregon doctor that was there, they are appalled that Maryland requires this. They don't think it should be required, and that's something you can read about. But the MOLST worksheet can be signed by you instead of the doctor having to sign it. And you can actually make the MOLST worksheet part of your medical record. So my real non-medical opinion is that the disconnect between the MOLST and the advanced directive is the worksheet. And I think you should talk to your doctor about whether you should have a worksheet or whether your loved one should have a worksheet if they have the capacity to sign it.
Well, they have to be able to sign.
And they have to be able to sign it, right?
Oh.
Because the worksheet is the input into the MOLST form. However, let's pretend your loved one signed an advanced medical directive, and let's pretend your loved one said, you, my agent, can change my decisions. Because remember, that's one of the choices. Your agent can actually be given the authority to change your decisions. So that might be a way to fill out a worksheet for your husband so that you can make some input into his MOLST form. Okay, it's complicated, but I encourage you to read about it because there's a lot of ambiguity with it. And that's why the head nurse from Anne Arundel Medical Center was saying, gee, these advanced medical directives are not, what they used to be, but they're still important. Okay, we're avoiding guardianship. We're going to have powers of attorney in place. We're almost done. We talked about the Maryland statutory power of attorney. That's not enough. It's not enough for elder law. It's better than nothing, and I would be thrilled if someone had at least a Maryland power of attorney. But it's not going to cover all of the really special areas like gifting, compensation, transfers of assets into trusts. It's not going to get into that kind of authority. But I won't go into all this, but these slides are about why the statutory power of attorney is not enough. And we need to enhance those powers. Lastly, we talked about the healthcare decisions a little bit earlier. Make sure that you populate your advanced medical directive as much as possible. Customize it. Look at all the things that you could put in there. And these are things I come up with. You don't have to have a plain, generic, advanced medical directive. You can actually customize this to any degree you want. What does Barbara Jacobs from Anne Arundel Medical Center say? She says, we don't get enough information from clients. So make sure that you fill this out and utilize all the blank space or attach something to the back of it and maximize expounding, let's say, on your wishes and desires. And if you don't really feel that you know how to do that, there's a couple of tools, and they brought these tools to us. And as a matter of fact, my firm has now kind of contacted the nonprofit organization that is providing these thought tools to clients. And if you would like to get one of those, they're very simple, but they're very useful, and Jeff can help you get them. And we talked about MOLST. So please, go to the Attorney General's website, read about it. If you can't do that or don't want to do that, Jeff and I will get you the information. Thank you, and I hope we have some time for questions. Thank you, Sandy.
Oh, thank you, Steve, very much. And I appreciate all of you with your diligent attention. I know this is a lot of subject material, and I'm sure we have some questions. So I've got about 2 minutes to 1. We'll start some questions. Yes? No? Maybe? Meryl, I know you have questions. Let's give somebody else a chance. Any other questions? Karen?
I have one. If you've been to an estate planner and they haven't given you this form, what should you do?
That is you've been talking about the MOLST form?
Yeah.
Well, that's a great question, and I believe that these individuals either don't know about it or they sincerely don't think that they should be delving into this. I'll give you an example. I was at an elder law conference in California. One of our most loved and admired elder law attorneys in Maryland was at the seminar, and on the break I said to him, "Hey, what are you doing, with the MOLST form? And are you showing it to all your clients?" And he said, "No, I'm not showing it to my clients at all." And I was shocked because his position was, "Gee, I'm not a doctor. I really shouldn't be talking to people about these forms." I feel exactly the opposite. I feel like our clients should know about MOLST and they should be proactive with it. So if your estate planner is not providing that to you, it's probably because they just don't deal with it, or they don't really believe that they should be delving into that with you. So that's why I would say get a copy of the MOLST material, and the next time you go to the doctor, say, "Should I have one of these?" Now, I'm not talking about a MOLST form. You look like you're too young and too healthy to have a MOLST form. You're not frail, you're not living in a facility, but maybe you should have a worksheet.
But is that done way ahead of time, or like you said, 48 hours for the nursing home?
Right, so let's pretend, here's a great example. I end up in the hospital, God forbid, I had a car accident. But what do they want to do at the hospital? They want to get me out of there as soon as possible. So they get me over to a nursing home. Now I have to, because I'm going to recover, I have to have a MOLST form within 48 hours of going into the nursing home. So they are going to fill it out for me. There's no question. The question is, do I know that if I have mental capacity, or does my agent know it, and do they know that it was even filled out? And my agent is my advocate.
So you fill the form and you keep it with who?
Well, the facility keeps it,
I mean, who do you give it to?
Well,
if you do that in advance.
The facility, okay, good question. The facility fills out the actual MOLST form and should give you a copy. And if you transfer facilities, they should transfer the MOLST form to the new facility. The worksheet is different. The worksheet is something you could fill out and sign. You could sit with your doctor and fill it out.
Okay.
And then that would be part of your medical record.
And then that doctor will transfer it to whoever.
You hope.
Well, you
And that's
hope.
why you have to either attach it to the back of your advance directive, make sure it's archived somewhere online, or make sure you carry it with you, as impractical as that sounds.
One more question. Is it a quick one, Meryl?
No.
All right, then we'll hold that.
I'll ask you.
We'll hold that for afterwards. Thank you again, everyone, for coming. I get a lot of subject matter here, and I know that Steve and Jeff would be happy to make appointments with you and talk to you about it in more detail. BWFA stands at the ready to help you in any way that we can. If you heard something here today regarding your investments or financial planning or taxes and you'd like some help with that, I would just let you know that Eve or any of my colleagues there would be happy to help you schedule an appointment. There's no cost or obligation on your part for coming back and having a conversation with us. In addition to those types of private conversations, we also do about 70 of these workshops a year. So come back and see us. I know we talked about Medicare and Social Security and many other things, all of which we have workshops on. So we'd be happy to see you again for another workshop at a time that's good for you. Feel free to leave your lunchbox there. If you're done with it, take it with you if you want to take some more snacks home for later. Thanks again for coming, and we'll be happy to chat with you for a little bit longer here as your time and our time permits. Have a great day. Thank you.
Thank you.
Thank you.